Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled, Is Filing an Answer Considered to be an Appearance? But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, I would like for you all to hit that like button, and also if new to my channel, hit that subscribe button, and also hit that notification bell so you all can be notified as I'm dropping these power videos. So without further ado, let's get to it. Alright, so now the reason why I'm doing this video is because there's a teaching going around online that by filing an answer to the complaint, it's considered to be an appearance. And because you filed that answer, which is considered to be an appearance, you do not have to go to court because your paperwork, which is your answer, made an appearance on your behalf, and the court cannot default you. So we're going to find out if that statement is true or not. Okay, so I'd like to ask you all that's watching this video, do you all believe that that statement is true? So again, let me repeat myself. The question is whether or not by filing an answer to a complaint that is considered to be an appearance. And because it's considered to be an appearance, you do not have to appear at the hearing because your paperwork made an appearance on your behalf, and the court cannot default you because your paperwork made that appearance. So if you guys believe that is true, then write yes in the comment section. If you believe it's not true, then write no in the comment section. And by the end of this video, you all will have the answer to your questions, okay? This is a better way for you all to get better understanding of what you're doing and what to do and what not to do when going into these courts, okay? For you all to get better understanding on how to properly defend yourself, okay? So now, as you all can see on the screen, we are in fact coming from the Black Laws Dictionary. Let's pick this up, highlighted in yellow, at answer. And it reads, highlighted in yellow, guys, answer. As a verb, the word denotes an assumption of what? Of liability. As to answer for the debt or default of another. Okay? So now, by reading this term or this definition for answer, I do not see the word appearance in it at all. Okay? But now, let's go down to pleading, since we're talking about responding back to the summons and complaint that we received from child support. Okay? So it reads, pleading, highlighted in yellow. It states, an answer to a pleading is simply what, guys? The response of a defendant to the plaintiff's complaint, denying in part or in whole the allegations made by the plaintiff. That's all a response to the pleading is, guys. Again, by reading this portion of the definition, do you all see the term appearance? I don't, but maybe some of you guys do. But let's continue on. It states, a pleading by which defendants endeavors to resist the plaintiff's demand by an allegation of facts, either denying allegations of plaintiff's complaint or confessing them and alleging new matters in avoidance, which defendant alleges should prevent recovery of on facts alleged by plaintiff. Here we go, guys. It states, in pleading under what? Codes and rules of civil procedures. We know that child support is a civil case, so it goes underneath what? Codes and rules of civil procedures. Now let's read what's highlighted in red. The answer is the formal written statement made by a defendant setting forth the grounds of his defense corresponding to what inactions under the common law practice is what? Called the plea. Okay, so that's why when you go to court and you're for a criminal matter, they say, what do you plead? How do you plead? Do you plead innocent or guilty? Okay, that's nothing but what? An answer, which is considered what? A response. That's it, guys. An answer is not appearance, but we're going to get there, and I'm going to show you that as well, okay? And it states what? Highlighted in yellow. See Federal Rules of Civil Procedures 8 and 12. You all will see that this same thing is written in Federal Rules of Civil Procedures 8 and 12, okay? But now, this is coming out of the Black Law Dictionary. Now, let's go to the Family Law Dictionary, guys. I just want to show you more. All right, so now, as you all can see on the screen, we are in fact coming from the Family Law Dictionary. And it reads, answer, noun, a defendant's first pleading that what? That addresses the merits of the case, usually by what? By denying the plaintiff's allegations. An answer usually sets forth the defendant's defense and counterclaims. So again, guys, that's all an answer is. Do you all see the word appearance underneath this definition? I don't. Maybe someone do though, but let's continue on. Answer as a verb. It states 1. to respond to a pleading or a discovery request. So again, guys, an answer is simply a response. That's it. That's all. That's why I always tell you guys you must respond when you receive documents. That's considered to be an answer. Okay? But let's continue on. Let's go to the next page. Okay, so now let's pick this up where it's highlighted at and where it states number 2. Let's read it. It states, to assume the liability of another. For an example, a grantor answers for another person's debt. Let's read definition number 3. Number 3 states, to pay a debt or other liability. For an example, she promised to answer damages out of her own estate. So again, guys, by reading the definition for the term answer, I do not see the word appearance at all. I don't know where they're getting that from, guys. But now, let's go over the definition for the word appearance. Let's get more understanding. And then after we go over the definitions for the word appearance, we're going to do what? Put them all together. All right? We're going to break this thing down so you all will not be confused no longer. So now, let's continue on. Let's go to the definition for the word appearance. Okay, so now, as you all can see, we are in fact coming from, again, the Black Law Dictionary. Let's pick this up where it's highlighted in yellow that states appearance. Appearance, a coming into court. I highlighted that in red, guys. Why? Because I can actually stop right there because that's all an appearance is, a coming into court. Okay, but let's continue on. It states, again, appearance, a coming into court as a party to a suit, either in person or by attorney, whether as plaintiff or defendant. The formal proceedings by which a defendant submits himself to the jurisdiction of the court. The voluntary submission to a court's jurisdiction. That's all an appearance is, guys. Do you all see the word answer in this definition? No, just like you did not see the word appearance in the definition for answer. Okay, and we're going to go deeper over that as well. So now, I also highlighted in yellow as what? In civil actions, we know that child support is in fact a civil suit, which makes it a what? A civil action. So now, let's pick this up where it states highlighted in yellow. In civil actions, it states, in civil actions, the parties do not normally actually appear in person, but rather through what? Their attorneys, and then their attorneys do what? Who enters their appearance by what? By filing written pleadings. So again, attorneys enter their appearance by filing written pleadings. Okay, if you're not an attorney, when you file your response, that is not filing an appearance. No, it's just filing a what? An answer. That's it. That's all, which is a what? A response. So now, let's read that again. But rather through their attorneys who enter their appearance by filing written pleadings or a formal written entry of what? Of appearance. That's it. That's all, guys. But let's continue on. Also, at many stages of criminal proceedings, particularly involving minor offenses, the defense attorney appears on his behalf. Okay? Then it states what? CEG, Federal Rule, Criminal Procedures 43. All right? It's just that simple, guys. But to further prove that, now let's go to the Family Law Dictionary to see what it states about an appearance. Let's go there. Let's get more understanding. All right, so now as you all can see, we are right back at the Family Law Dictionary, and it states what? Highlighted in yellow, appearance, which is a noun, and it states what? A coming into court. I can stop right there. That's why I highlighted in red. The same thing that was stated in what? The Black Law Dictionary. Like I always tell you guys, out of the mouth of 2 or 3 witnesses, let each matter be established. So this is the second witness. So let's continue on. It states what? Appearance is a noun, a coming into court, as a party or interested person, or as a lawyer on behalf of a party or interested person. Also see appear. So now, guys, do you all see the word answer underneath the definition for appearance? No, just like you didn't see the word appearance under the term answer. So I don't know how people are using these things interchangeably when they're not. They're 2 totally separate things, and answer and appearance are not the same. Okay? To further prove that, let's go to Cornell Law School, which will be the what? The third witness. But let's continue on. Let's go there. Okay, so now, as you all can see, we are in fact come from Cornell Law School. Let's pick this up where it states appearance, and it reads, a party enters an appearance when they show up to court in response to what? Service of process. All right. So an appearance is to show up to court. There is no difference. It's stating the same thing. This is the third witness. Out of the mouth of 2 or 3 witnesses, let each matter be established. We know a service of process is what? To be served with summons and complaint. Once you're served with summons and complaint, that's procedural due process, meaning they what? They're giving you a right to defend. That's what procedural due process is. But let's continue on. It states, appearance isn't only a reference to physical presence in court when required, but also to procedural compliance. Okay? That's why it says, but also to. Not absent of, but also to. Okay? States what? Procedural compliance. e.g., filing an answer. Okay? By filing an answer, that's a procedural compliant. But that does not remove the obligation of appearing to court once you've been summoned with service and complaint. Why? Because that satisfies procedural due process, which is what? Service of process. Okay? So now let's pick this up at the top where it states filing an answer. Let's click on answer, guys. Alright, so now as you all can see, answer. An answer is a reply to a question or a solution to a problem. Let's continue on. In law, an answer refers to a defendant's first formal written statement to a plaintiff's initial petition or complaint. This open written statement will admit or deny the allegations or demand more information about the claims of wrongdoing. Mostly, an answer includes the defendant's counterclaims, allegations, or claims against the plaintiff and or affirmative defenses, legal defenses that can defeat the plaintiff's claim. That's all an answer is. So again, guys, by filing an answer, it's not a form of appearance. No, it's a part of the procedural process, but it's not an appearance. But now let's go back to appearance. Let's go there. Okay, so now let's pick this up where it states, but also to procedural compliance right here. Procedural compliance, e.g., filing an answer, participating in discovery. Typically, making an appearance means that you consent to the court's exercise of personal jurisdiction over you, and you therefore waive your right to challenge it later. This type of appearance is known as what? A general appearance. Then it states, failure to appear after being served will what, guys? Result in a default judgment against the party who what? Failed to appear. So that's the answer to the question, guys. Even though you filed an answer, if you do not show up into that court building after you file your answer, the judge will enter default judgment in, especially if you was filed with, if you was proven to be served with summons and complaint. Why? Because now you're waiving your procedural due process rights to contest and to be heard. Okay? So anyone telling you guys to file an answer but don't show up because the court cannot default you is a lie. Okay? Matter of fact, let's go to what a default judgment is. Alright, as you all can see, judgment by default. It states, judgment by default, also known as default judgment, is a judgment entered upon the failure of a defendant to appear before a court or answer a complaint. Then it states a default is a failure to perform a duty in legal proceedings. A default judgment is binding, and the defaulting defendant may not litigate his case or present any evidence. A civil action default judgment will grant the amount of relief sought in a plaintiff's complaint. In the United States, the law governing default judgments can vary in different jurisdictions. So again, guys, that's what a default judgment is, okay? Just because you filed an answer, that does not prevent you from having a default judgment, okay? Now let's go back to Cornell Law School for the term appearance. Let's go back there again. Okay, so now let's pick this right back up where it states failure to appear. And it reads, let me highlight the whole thing. Failure to appear after being served. That's why it states after being served, guys, because once you're served with summons and complaint, then that's when the court exercises jurisdiction over you. Why? Because now they're granting you procedural due process rights. To do what? To admit or deny the allegations that's against you. If you refuse to admit or deny and you refuse to appear before the judge, then what? The court will enter default judgment against you despite filing an answer or not. Let's continue on. It states, failure to appear after being served will result in a default judgment against the party who failed to appear. And it's just that simple. But let's continue on. If a party does not believe the court can exercise personal jurisdiction over them, but does not want to risk the possibility of a default judgment nor the risk of losing an otherwise valid lack of personal jurisdiction defense, they can enter a special appearance for the exclusive purpose of what? Of determining jurisdiction. In federal court, there is no longer a distinction between a general or special appearance. However, a Federal Rules of Procedures 12B motion allows a party to accomplish the same thing a special appearance would. A party can make an appearance either in person or virtually, right? Then it states what? Although the availability of these depends on the specific court and specific issues. So again, guys, I cannot stress this enough. If you do not appear after you file your answer, then what? You are at risk to what? a default judgment, as it clearly states. But not only that, guys, since the person that's also teaching this information resides in Georgia, let's see what Georgia states. Let's go there. Let's read Georgia code. Let's go. Okay, so as you all can see, again, we're coming from Justia. Let's pick this up where it states Georgia code, subsection 9-11-4. A, where it states summons. This portion deals with the what? The issuance of a summons, okay? And it states, upon the filing of the complaint, the clerk shall forthwith issue a summons. So now, guys, once the plaintiff filed a complaint into the court, the clerk of the court shall do what? Issue a summons, right? Why would the clerk of court issue a summons? Because it's a part of what? Procedural due process that's granted by what? The Constitution of the United States and the state's Constitution. Then it states what? And what? Deliver it for service, which is more evidence. For service of what? For service of process, which is also what? Protected by what? The United States Constitution and the state Constitution for what? Procedural due process. That's it. That's all. Notice. Once you receive notice, then it's on you to defend. You can waive your defense and simply submit by doing what? By not responding and not appearing. But let's continue on. It states, upon request of the plaintiff, separate or additional summons shall issue against any defendants. Let's pick this up where it states B. B, summons. Right here, summons. And it states form. So this is the form of the summons, okay? It reads, the summons shall be signed by the clerk, contain the name of the court and county and the names of the parties, be directed to the defendant, state the name and address of the plaintiff's attorney, if any, otherwise the plaintiff's address, and what, guys? And state the time within which this chapter requires the defendant to what? To appear and what, guys? And file appropriate defense pleadings with the clerk of the court, and shall notify the defendant that in this case of the defendant's failure to do so, judgment by default will be rendered against him or her for the relief demanded in the complaint. Okay? So they must do what, guys? They must appear, okay? For the defendant to appear and file the appropriate defenses. If they just file the appropriate defenses and does not appear, they're still at risk of what? A default judgment or a judgment by default. Okay? So, guys, do not let anyone tell you guys by simply finding an answer you do not have to appear. Okay? That person is going to find out soon that they are in fact in default when they receive that default order. Okay? And once that person receives that default order out in Georgia, I keep telling you guys, stop listening to people who claim that they won child support and they never did. The person is mixing up custody with child support. The person is arguing custody in the child support hearing. The guy's making a fool out of himself, guys. Okay? I'm going to give y'all more information on who I'm talking about and stuff like that. I'm going to bring it all out, guys. You all going to see shortly on how I keep telling you guys that the people that's telling y'all to file these forms, such as power of attorneys, color of law, the state has power of attorney over you, these cats does not have a clue what they're talking about, guys. And you all will see once that default order hit that website, all right? But again, that's what I'm going to do for today. If you all need my help, hit me up in my email at y'allsmagnified@gmail.com. Let's continue to apply pressure. Let's get this right wisdom, this right knowledge, and this right understanding. Like, share, and subscribe. With that being said, I say shalom.